There it is. You walk into a department store and someone else is making and selling your invention. Is there anything you can do to stop the infringement? Let's get into it in this video. Hi, my name is Carr Ferrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. Reviewing patent law briefly. In the United States, if you invent something and you take the time to write it down and submit it to the patent office, in exchange for your troubles, the patent office will grant you a 20-year exclusionary monopoly to stop others from making, using, and selling your invention. The remedies for patent infringement are that you can go to a court and ask a judge to grant you an injunction, that is to stop the infringement, and in addition, you may be entitled to money damages, and in the case of willful infringement, you may be entitled to up to treble damages, 3 times the damages that you suffered, in addition to having your court costs and attorney's fees paid by the infringer. The statute of limitations for patent infringement is 6 years, so you're entitled to collect damages for up to 6 years prior to the filing of the lawsuit for patent infringement, so long as your patent application has been enforced. If an infringer has been selling a lot of product for the past 6 years, those money damages can really add up. But filing a patent application and waiting for your patent to issue can often take several years. So does the infringer get a free ride until your patent is actually granted? And the answer to that question is no. Patent damages can actually accrue prior to your patent application actually being granted in what are called provisional patent rights. So what are provisional patent rights? Well, the name is a little confusing because it has nothing to do with provisional patent applications or PPAs. Provisional patent rights refer to the rights in your patent application that begin to accrue at the time of publication and before the patent is actually granted. Patent damages normally accrue from the time that the patent lawsuit is filed until the patent infringement stops. As I mentioned, it is possible to get damages up to 6 years prior to the filing of the patent lawsuit. But as your patent application was pending, and if it was published, then it's possible under 35 U.S.C. 154D to potentially get damages from the time of publication of the patent application. Now, publication usually occurs at 18 months following the earliest filing date of the patent application, whether this is a non-provisional patent application or a provisional patent application. Now, under provisional patent rights, you don't have to wait until your patent actually issues to begin accruing damages, but again, those damages can begin accruing from the time of publication. Now, it's important to note that you don't actually get paid. You can't actually collect the damages until after your patent issues and you bring suit. But the damages begin to accrue from the time of publication of your patent application. Now, if you do eventually file a lawsuit to collect money damages for infringement of your patent, in order to get provisional patent rights, there are 2 important requirements that must be met. And by the way, if you're finding this video at all helpful, it would mean so much if you could like and subscribe because it triggers the YouTube algorithm to help promote and support this channel. And if you'll leave a comment in the comments section below, I'll do my best to respond to you. So what are the 2 requirements that provisional patent rights require? Well, the first requirement is that the infringer of your patent application has to have actual notice of the application. This is a matter of fairness. It's akin to running through a stop sign where the stop sign is hidden by a bush. You need to know that the stop sign is there. You really need to know that there's a patent application that has been published. It's not enough, for example, just to have a published application or to put patent pending on your product. You must actually make the infringer aware that you have a patent application that has been been published that's potentially covering their infringing product. Now, the most certain way to assure notice on the part of the infringer is to send the infringer a letter and a copy of your patent application. It doesn't need to be a mean or threatening letter, but just enough to put the infringer on notice about the existence of your application. An example of this might be, "Dear Mr. Smith, we note that your company is manufacturing and selling decorative handlebars, and we wanted to let you know that our patent application just published covering decorative handlebar streamers. Let us know if you're interested in a licensing arrangement or in purchasing handlebar streamers from us." The second requirement for asserting provisional patent rights is that the patent claims published in the patent application must be substantially the same as those that are issued when the patent is granted. So in order to assert that patent damages began to accrue at the time the patent application was originally published, the claims in that application must be substantially unchanged from those that are being currently infringed. Provisional patent rights aren't really well known, but they can be a terrific weapon and deterrent against infringement by inventors who have patent applications on file, but whose patent applications haven't yet issued. And this is another great reason to get your patent application on file early, to get that 18-month clock started to publication. Even a provisional patent application will get you closer to that 18-month publication date. There's so much more to say about patents and patent protection. If you found this video useful, I know you'll like this next one also. I'll see you over there.